You're all right.
Have you moved?
Pardon?
Have you moved?
No.
Do you know what the thing is for the door? It was there yesterday.
COVID getting in the way at the moment. But, you see, I'm spending a lot of time there anyway. Going down there tonight and spending all Christmas with a girlfriend. Good. No arguments on Christmas Day. Yeah. Do you know where the Sings room is?
Second floor.
Good. Card to deliver.
No, mine. First floor.
First floor, alright.
Yeah, definitely first. Let's go.
Got rice? Appeal in the matter of Moore Stephens LLP and others and Parr.
Yes, Mr. Kelly.
May it please the court, I appear for the claimant and appellant here, Mr. Philip Parr, Mr. Stillitz QC for the LLP. I suspect that I can deal with the facts in very short order indeed, because the court will be, no doubt by now, very familiar with them. But if I may, I'll simply...
Is there any quarrel with the facts as set out by Mr. Gullick in paragraphs, I think, 7 onwards of the EAT decision?
I don't believe, my lord, there's any quarrel about the facts, but there certainly is some quarrel about the approach he takes to the proper construction of the LLP Members Agreement. Whether one calls that a fact or not may be a moot point, but I'll certainly need to deal with that quite carefully, because what the EAT does is to treat the relevant provisions in the LLP Members Agreement as a discretion. I agree that there is a discretion, but the retirement provisions are not discretionary in the sense that they apply to everybody. So I'm going to have to deal with that quite carefully. But otherwise, I don't think, my lord, looking at the facts as I was going to explain them, that there is likely to be any dispute. So if the court's content for me not to deal with them, I'll get straight into submissions. What I propose to do is to deal with matters in this order. First of all, to look at the legislation, the present legislation, and then to look back at the RRA and the SDA to see what effect that had. The next thing I'm going to do is turn to the LLP Members Agreement, and at that point I'll address what I say was the EAT's first wrong turn, which is their approach to what is described as the discretion. My third point will be to go to the Ames and Kapoor line of authority to see what learning one takes from that. And then the fourth point will be to deal with what I say is the EAT's second wrong turn, and that's to decide that a rule must be in action, as they say. It must be operating in some way, rather than the simple existence of a term in a contract. So that, my lord, is the order I propose to take. And if I could start, please, by addressing the legislation, one needs to begin with the RRA and the SDA, because they're in identical terms. One only needs to look at one of them. If we start at tab 1 of the authorities bundle, we have the time provisions in the RRA as they were prior to its replacement by the Equality Act. And the provision that we need to look at is 68(7).
Can I just see whether you've referred to this in your skeleton argument?
Yes.
not because I'm going to forbid you to refer to it if you haven't, but it's easier not to have to write it all down
Yes.
if you've got it there
Yes,
already.
it's section D at paragraph 10, which in your bundle, my lord, is page 19.
Yes, got it, thank you.
So, my lord, perhaps I'll give you the headline and then look at the detail of it. The point is that the earlier legislation made specific reference to the inclusion of a discriminatory term in a contract. So what it didn't do was leave the language of act extending over a period, or as it now is in the Equality Act, conduct extending over a period, to do the work in respect of contract terms. It made separate provision for them. And if my lord has open the RRA, well, you can look at my skeleton at paragraph 10, because
Yes.
I've set it out there. It's A. And one found that provision in both the RRA and the SDA right up to the Equality Act.
When the inclusion of any term in a contract renders the making of the contract
Yes.
an unlawful act, what's that all about then?
So, my lord, the contract would always be unlawful if it included a discriminatory term. So it's just another way of saying there is an unlawful term in a contract.
When
And
it
what
says the term of the contract renders the making of the contract unlawful.
Yes.
Just the inclusion of the contract term that's discriminatory.
Well, my lord, if you and I sought to make a contract and included within that a term which was discriminatory, the making of the contract would always be unlawful. And I'll show you in a moment. In fact, perhaps it's worth going to it now, because this point did arise in Kapoor. And just before I turn to it, I'll tell you what happened there. In Kapoor, the decision of the House of Lords was reached after the RRA came into force, but the contract was made prior to the RRA coming into force. And what the House of Lords said in Kapoor was therefore that there couldn't be reliance upon paragraph A, because the contract had already been made at a time when it was lawful to make it. So what they had to do was that they nonetheless found there was an act extending over a period, but had to bring it within B rather than A. And let me show you that. If I take you to Kapoor, which is page 19 of the authorities bundle. The particular part that my lords will need to look at is page 31 of the authorities bundle, which is page 367 in the speech of Lord Griffiths. And if my lords could read down, please, and my lady, from B to G inclusive.
Sorry, yeah. Page 365.
It's page 31 of the authorities bundle, at least in mine.
Okay, yes.
And it's Lord Griffiths.
367 of the report, yes.
367, yes, and it's B to G inclusive.
Yes.
And this point is touched on once more in the Sugran decision in this court, which is page 51 of the authorities bundle. And if my lords and my lady look just under the C on page 51, in Kapoor's case it was unnecessary to consider the scope of section 68(7)(a) because the contracts of employment predated the Act. The argument was therefore concerned solely with paragraphs B and C. It is, however, reasonably clear that if this had not been the case, paragraph A would have applied. So there's no doubt that the judicial learning on A, if I can put it that way, is that if one can identify a discriminatory term, the time period for complaint about that discriminatory term it does not start to run until the term is abrogated or the relationship is terminated. So that was the position right up to the Equality Act. I'm simply pausing, my lord, because it looks like a difficult question.
I'm just thinking about it. How, taking the example given by Lord Griffiths for using black rather than coloured as the adjective. If you have a white employee with long service with a pension at 1/60th, and a black employee long service with a pension at 1/80th per year, how can that not be a continuing act or an act extending over a period? Of course it is.
Well,
but so what?
Well, Lord, the reason that it's a continuing act, just to, without at the moment deciding under which limb it would have arisen under the RRA or the SPA, is because it is a term of a contract which provides for differential treatment. If one thinks about...
a term of a contract which provides differential treatment and continues to operate throughout the employment relationship.
It continues, my lord, to have consequences throughout the relationship. By continues to operate, that might mean a number of different things. There is in Kapoor I can put it this way, a one-off decision which is taken. The employees are coming over from East African banks, and the bank has to decide whether they are going to be credited or not credited with their years of service with the East African banks. What Barclays decides is they are not going to be credited with that service.
Or put differently, in calculating the pension to which they're entitled under their contract of employment with Barclays, how do you calculate it? Do you include previous years or current years? But the moment of calculation comes when you finally retire and take the pension.
Mr. Parr could make exactly. Mr. Parr could make exactly the same.
But that's what he needs to do, I think.
Well, my lord, with respect, I don't think that's right. I'm jumping ahead a little in my submissions, but it's probably a good time for me to do that. Can I show you why that's not the right answer? The reason is that what all of the authorities say consistently is that where you can identify a term, a rule, a policy, doesn't matter what it is absolutely irrelevant to look at the date on which there is application.
If it's you can't get a mortgage if you're a woman, or you can't get, I don't know, discretionary leave if you're Welsh or something, then yes, I accept that you don't have to apply and so on, if that's what you're saying.
Yes, but that deals precisely with my Lord's point, because what the legislation does is it bites on the term
Of
or
the
the rule or
contract,
the
not
policy.
the particular day on which they seek to get the benefit.
Yes,
of
not the
Yes,
application, if I can
yes,
put it that
yes,
way, not
yes.
the consequences. So
Not the date of application, it's the term of the contract. And so long as the contract continues, and so long as there's a discriminatory term in the contract, time continues, and that, you say, is this case.
I do, and indeed, if one just thinks about the word application for a moment, there's no magic in that word, but if one thinks about application is built in where you are dealing with a term of a contract, because there is always application, because it's a contractual term between employer and employee, or LLP and member, as the case may be. And unless and until that term is abrogated or the relationship terminates, it is operating. Has to be, because it's a matter of contract between the parties. So it is important for that reason to look at the language of the RRA and the SDA, because that's what it tells you, where the inclusion of any term in a contract renders the making of the contract an unlawful act. That act shall be treated. One might say artificially treated, but nonetheless treated as extending throughout the duration of the contract.
Well, the whole point about the word treated is that it is artificial. It's a deeming provision.
Exactly.
Saying something that isn't X shall be treated as if it were X.
Exactly that, my lady. Exactly that point. It's a deeming provision. And it follows, without going any further into the authorities, that unless there has been a change in the legislation so that the time provisions are in some way narrower than they were before, then the law is exactly as it was. Now, my learned friend, I don't think is saying that there's been any change in the effect of the legislation, certainly not in his skeleton. If we look at the Equality Act, my lords and my lady have the relevant provisions at page 133A.
The time-honoured tradition of authorities bundles has originally filed. The one page which really mattered wasn't there. Anyway, we have it now.
I handed it up this morning, and you have my apologies for that.
We have it now.
But yes, I'll turn, if I may, to that in a moment. But
I'm afraid I don't have it.
my lords and my ladies should have two things. There should be section 123 in the bundle, and section 45 I handed up this
I've got
morning.
section 45 of this, but I haven't got section 123 in my bundle.
Page 133A, no.
There's no 133A, you see, there's 133, which in my bundle is the explanatory notes.
Yes, and there should be a 133A, which is section 123.
No. So the explanatory notes were thought to be more important than the section itself.
Not by me.
The Act isn't in there. We haven't got the page that's got the text of the Act. Whatever number you want to give it, it's not in the bundle.
Well, can I I'll make sure that copies do come over. Can I?
It's set out in the terms of the judgment of Mr. Gullick, you see.
I'm sure it will be.
So I was looking for it. It straddles pages 76 and 77 of the core bundle.
Yes. Thank you, my lady. I'm very grateful for that. So if one looks at section 123(3), the word act has been replaced by the word conduct. And the provisions in respect of contract terms have been removed altogether. If my lords and my lady go to the explanatory notes of the Act, page 133, paragraph 400 is the paragraph which describes the effect of the legislation. And at 401, this section is designed to replicate the effect of provisions in previous legislation.
Well, that's all very well, but I mean, the question is whether the language does that, isn't it?
Well, it's of some assistance. I reminded myself, principles of statutory interpretation, that one is normally looking to find some positive evidence of a reason for a change to determine that there has been a change. I have looked very hard to see if I can find anything, any consultation that would herald any intention to amend the legislation, any debate in Hansard, any reason to change the legislation as it was before because it was in some way not operating in a satisfactory fashion, and I can find nothing.
Presumably what you say is, what they've done is replaced act with conduct, and by reason of replacing act with conduct, conduct is broad enough to include what was in the old A and is now to be found in the new A.
I say, my lord, exactly that.
Yeah.
And one more thing to go with it, which is section 45, which I handed up this morning. So these are the provisions which set out the various different forms of discrimination that a person might suffer. These particular ones deal with limited liability partnerships in section 45. Their language is very similar to the provisions which apply to employees, but modified to deal with members of a limited liability partnership. Section 45(1) is dealing with applicants for membership. Section 45(2) is dealing with existing members, and one sees the four types of discrimination. 2A as to the terms on which B is a member. So one already has built into the legislation the concept of discrimination by virtue of the membership terms. There is no need for section 123 to do anything else but say conduct extending over a period, because insofar as there is a term of membership which continues to operate, which hasn't been abrogated, that of its very nature is conduct extending over a period. So it follows.
Is Mr. Parr still a member of the LLP?
So at the time of his bringing Employment Tribunal proceedings, he remained a member of the LLP. In my learned friend's skeleton, there is a reference to re-engagement, which is a point that he made both in the Employment Tribunal and in the Employment Appeal Tribunal. In both of those courts, that point was rejected because there was never a re-engagement. Mr. Parr remained a member of the LLP at all times. What changed was his equity. He was de-equitized.
Well, it's the terms of his membership, not his membership, which were varied or changed. The relationship didn't end and start again on new terms. There was one relationship, and it was varied,
Yes.
or altered, or amended in the way described.
Even then, my lord, I'm not sure. I don't think it matters. I don't even know if it would be quite right to say the terms changed, because he remained bound by the same members' agreement at all times.
Some of the
just
terms were the same, but other terms were not the same.
The de-equitization deed, I agree, was some moderate variation.
It must have been a change of the terms.
Yes. Prior to the de-equitization, the LLP members' agreement recognised different classes of member. So therefore, he didn't need to sign up to a new LLP members' agreement. He remained bound by the existing one. But subject to that point, I agree with what my lord says. So the terms of membership, subject to my Lord Justice Lewis's point, the terms remained the same throughout. What changed was status. And so section 45(2)(a) is important because it shows you that one of the forms of discrimination are the terms on which a member has their membership. Here, a term remained discriminatory throughout.
That's why I think you've really got to look at 29.2 and 29.4, because you're describing a state of affairs as a fact and saying, therefore, it falls within it. But you need to look at what actually happened in the terms of the LLP. I think that's the difficulty I've got with you at the moment, is we're treating as a given something which is the very issue.
Well, my lord, can I take that invitation?
Yes, we've taken you out of your course, or maybe you've taken yourself out of your course, because here we are looking at case law on the now replaced statutes before we've actually looked at the members' agreement. So let's do that.
Well, my lord, supplementary bundle, please. And it's 29 that we need to look at, and that begins at page 28.
I mean, do we need to look at anything more than the citation from the agreement, which is in the decision of the EAT on page 4 of the EAT's decision?
No, I don't believe so.
Let's look at the original. I've got there now. Supplementary bundle.
And the particular provisions we need to look at are 29.2 and 29.4. 29.3 is an attempt at reciting justification. Yeah. I don't think it's relevant to anything this court has to decide. 29.2 is a provision which funnels every member of a particular age into a pool. So the default rule is that every member retires just after 60. And I'll come back to that rule in a moment. 29.4 is a discretion. And it's a discretion to displace the ordinary consequence of 29.2. Perhaps I'll just pause whilst the court reads that and then make some observations about it.
Yes.
Now, in my learned friend's skeleton for this appeal, he says there are three possible outcomes. There's either compulsory retirement, there is an extension of one's membership, or there is the offer of an employment contract. And that's not a fair summary of what 29.4 does, because what it suggests is that there is a world in which the over 60 who goes into the retirement pool comes out of it unscathed.
No, read the words. 29.2 says each member shall retire just after his 60th birthday. But that is subject to 29.4. 29.4 says the normal retirement date of an individual member may be extended. It's got to be extended for a specific period and on such terms as to remuneration and otherwise as the manager may determine. So for that individual, his normal retirement date is a later date because of the agreement.
Well, my lord, yes, but that skips over rather quickly what happens to that individual. Because whereas they go into the retirement pool with what I might describe as unlimited membership, once they go into 29.4, the best possible outcome that they can hope for is a time-limited extension to their membership.
Yeah. They don't go into a pool. Their normal retirement date is defined by 29.2. A different extended normal retirement age for that individual can be reached on the terms and in the circumstances set out by 29.4. That's what those two clauses say.
For a time-limited period. So that's why I say...
It's renewable, isn't it?
And, my lord, that's a point I'm coming on to in a moment. It is subject to the LLP's discretion, renewable. But nonetheless, anybody who reaches the retirement age, if the suggestion is to be made that, in fact, what one can do is get to that age, and the LLP then say, but we're not going to apply these provisions to you, that's not right. Because even on a best case scenario, your unlimited membership of the LLP becomes one for a time limited period.
You're building things in. It's not about limited membership or equity membership. It's the normal date of retirement is 60, full stop, or just after 60, full stop.
Yes.
But that is subject to another provision. And that provision, for an individual, allows you to extend the normal retirement date. But on terms and for a specific period. And what seems to have happened here is they've extended it, I forget if it was for 2 years.
2 years.
But on certain terms, i.e. that he doesn't remain an equity partner, the period of the extension of the normal retirement date, but on terms that he's, I forget what the phrase is, a salary partner or a non-equity partner.
Yes. And, my lords, but for clause 29.2, he would have remained an equity partner.
No, 99, but for clause 29.4, he'd have retired at just past 60.
He said but for 29.
Well, that's a... If I may say so, my lords, but for arises at a subsequent stage to the application of 29.2. But for clause 29.2, Mr. Parr remains an equity partner with unlimited membership. In other words, his membership continues without any...
Not after 60, it doesn't.
Yes.
Well, but for clause 29.2, it does remain. Because if clause 29.2 were not in the agreement, there'd be no retirement age at all.
And that's his case. Simple as that. 29.2 may have a discretion to partially apply, but nonetheless, without 29.2, the discriminatory consequence doesn't ensue.
But he's not complaining about the retirement date of 60. He's complaining about the fact that when it was extended for 2 years, it was extended on certain terms.
He's complaining about clause 29.2. Without clause 29.2...
People would be members for life.
Yes. Yeah. As they are in very many professional services partnerships, because one sees ordinary retirement dates less and less and less. And so if what Mr. Parr is able to do at trial is to establish that, let me put it another way, if the LLP is not able to establish that clause 29.2 is justified, because 29.2 is obviously a discriminatory provision, then Mr. Parr establishes that 29.2 is direct discrimination. In terms of what damages he recovers, the court looks for but-for consequences. And he says, and it's not for determination at this stage, but seems to me to be fairly obvious, but for 29.2, he would have remained an unlimited equity partner, same status, unlimited in time, and he would have benefited from the transaction proceeds, which in the event he didn't. And that's his case.
Yes.
So
right.
29.2 is a... I'm sorry, my lord, I interrupted you.
No. I think I understand that. I'm not sure why you and my Lord Justice Lewis were getting into such a debate about the number of options under 29.4.
He'd have carried on if it weren't for the normal retirement date.
Yes.
And that is in 29.2, you say, and there's a discretion to extend it, but the discretion follows on from the normal retirement date. So if the normal retirement date goes, 29.4 has nothing to do with it.
And I accept that.
Yeah.
I accept that. I think the only point that I was trying to make to my lords and my lady, and it isn't on my case a significant one, but the only point I was trying to make is that 29.4 is not a provision whereby the LLP can decide that they're not going to do anything at all. For example, simply displace 29.2. Because even on a best case scenario for the member who reaches the retirement age, they get a time limited extension. So whereas once their membership was unlimited in time, it becomes limited in time. That's the only point that I was trying to make. It doesn't.
That's right. I don't understand that. I mean, I don't understand the significance of it, but I just don't understand it. That there is, under 29.2, for good or ill, everybody's membership is prima facie limited to age 60. Under 29.4, if there is agreement, the normal retirement date may be extended, postponed, changed to a different one. Suppose it's 2 years. At age 62, the process potentially is repeated.
Yes.
So you're quite right that at age 60, either you retire, or by agreement you continue on such terms as the managing partner may determine, and by implication you agree to, because you've not been made to stay on. Or there may be agreement that you don't continue as a member, but you are employed. I think I've got that, but why is it important?
Well, I don't say it is important. I simply rely upon it to show that, in case the point is made against me, 29.4 does not ameliorate the discriminatory effect of 29.2. It's just part of the machinery.
The problem here is his date was extended on particular terms.
Yes.
And you're complaining that for the period of extension, those terms were wrong.
Well, it starts before that, my lord.
Well, you say having to get to that because of the fact you'd have to get to discretion. Your point is, because everybody's cut off at 60 without the exercise of discretion, any unpleasant consequences included in the extension terms have their origin in and involve a continuing act by reason of the 60 age to start with.
Yes, the 29.2 is the conduct extending over a period, and if there is any issue about causation of loss, it doesn't arise for determination at this stage. It would be an issue for trial. But can I also pick up?
The moment you have a retirement age, any subsequent change in the dates or the terms that you remain after the retirement date are necessarily within the scope of the time limit, because they always follow automatically as the result of retirement date.
Yes, but there is also a further observation to make about that, and it's this. As my Lord Justice Bean says, once there has been an extension, then at the end of the extension there might be a further extension. And so it follows as a matter of fact. I don't say any of that matters one bit for the purposes of deciding whether there's conduct extending over a period. But as a matter of fact, the notion that the application of these rules is one time only is not right. Because once the member gets to the 60 age, this machinery continues to operate. So if you take the present case as an example, Mr. Parr gets to 62, he has his 2-year extension, and then he's thrown back into the Clause 29 machinery, and once again, the LLP is entitled to make a decision about whether they'll let him stay, whether they'll make him go, and if he's going to stay on what terms. So even on that basis, when the EAT say, we'll look at their judgment shortly, when they say this is a one-time act which doesn't in effect continue because the contractual term has exhausted its application, that's simply not factually correct. Hasn't exhausted its effect on Mr. Parr at all.
But I imagine you accept that if on Mr. Parr's 60th birthday, the managing partner has said, we're not extending anything, in fact we want you out of the building by the close of business today, that would be a one-off act.
He would have, because his membership had terminated, the term would no longer apply to him, so he would have 3 months to bring his claim in the Employment Tribunal. Yeah. Is I think the way I would prefer to express it. Calling it a one-off act relies upon the conduct of the managing partner rather than the term. And that's a significant difference.
What is it? Well, it's the term. In the scenario I've just put to you, which if he were an employee would be a straightforward dismissal, but it's not. 29(2) kicks in, and he retires. And the only way that 29(2) can be overridden is by agreement under 29(4).
Yes.
And if the managing partner were to say, I'm not agreeing anything, I'm not even discussing it, the enforced retirement would, you say, be an act of direct discrimination, but it's direct discrimination which derives from 29(2).
I agree.
The fact that it would have permanent financial consequences to him would not make it conduct extending over a period any more than it would in a straightforward dismissal case.
I entirely agree with that.
But you say that because it's not as stark as that and he remains a member, that is conduct extending over a period.
Well, there is one fundamental difference, which is in my Lord's scenario, the term does not continue to operate because membership has been terminated. So therefore, the member can't rely on the term anymore. The 3-month clock has started to tick. But if membership continues and the term continues to be incorporated in the members' agreement...
Which term?
What I will call the mandatory retirement age. Because that is the term complained of. It's a term which invariably has discriminatory effect subject to justification. And whilst that term continues to be incorporated in the members' agreement, or indeed any other agreement between member or employee and employer, time doesn't begin to run. The court is and has always been unconcerned with the date on which there was application of the term. What the court is concerned with is the term. And I'll shortly show the court some further authority for that proposition.
So you say that 29(2) continued to be a term of the contract between Mr. Parr and the partnership.
That's common ground.
Is it?
Between my learned friend and I. Well, it must be, because Mr. Parr remained a member at all times and a party to the Llp Members Agreement.
Well, 29(2) defines the normal retirement age. It's subject to clause 29(4). and it says each member will retire on the normal retirement date. But that isn't the case for Mr. Parr, because he got into clause 29.4, and the clause that determines his retirement date is 29.4 because it's been extended.
Well,
They got a different one. It's not, it was 60, it's now something else. It would have been 60, but because of the agreement, it's 62.
Or to put it another way, once you've reached your normal retirement age as defined, the effect of 29.2 is exhausted.
Well, my lord, that's my lady. I'm sorry. That's
Don't
wrong
worry, it's fine.
for two reasons. It's wrong, first of all, for the factual reason I gave earlier, which is that its effect isn't exhausted, because all that happens is 29.4 amends the normal retirement date by virtue of the period of the extension. So once that period ends, one is back into 29.2 with a new normal retirement date. So it's even factually not correct. But 29.2 always continues to be a term in the agreement between Mr. Parr and the LLP because it is a term in the agreement between them.
It can't be. Just a way to construe what happened. Sorry, I can't remember the date, but when he was 60, he and the partnership agreed an extension, but on terms that he was de-equitized.
Yes.
Is that right? That meant that there was an agreement that his member's normal retirement date would be his 62nd birthday.
Yes. His new normal retirement date.
His new normal retirement. But I don't see how you say that 29.2 remains a term of the contract.
Well, my lord, from first principles, it remains a term of the contract because it's not varied. It remains incorporated, and so it continues to be a term of the contract.
One question is how do we determine what Mr. Parr's normal retirement date is? And the answer is you've got to look at 29.4 because 4 lines from the end says any agreed extension should be for a specific period of time, the conclusion of which will represent that member's normal retirement date. His normal retirement date is no longer fixed by 29.2. It was the fact that he was reaching that date that triggered the need either for the date to remain the same or for a different normal retirement age to be agreed. But a different normal retirement date was agreed on the terms of this, and it is that which is Mr. Parr's normal retirement date. So it remains physically in the contract. It would have been had there not been a switch to 29.4, because 29.2 is subject to 29.4. But what happened was that a different set of terms defines his normal retirement date. So 29.2 was the factual occasion upon which the parties agreed and had to agree a different retirement date.
Well, I take issue with that,
Yeah.
my lord. I don't, as a factual summary of what happened, I don't necessarily disagree with it, but it doesn't change the term. The term is that the normal retirement date is the count's date next following his 60th birthday.
The normal retirement date subject to clause 29.4.
Yes.
And you read 29.4 and that provides for a different normal retirement date. And it's that clause that applied here.
Well, it doesn't do that. What 29.4 does is to give a discretion in any particular case to do certain things.
Yeah.
But the complaint that's made is in respect of clause 29.2. And once one appreciates from the authorities that the date of application of a discriminatory term, policy, regime, whatever one wants to call it, is absolutely irrelevant, and it's the policy, the regime, or the term which one is entitled to complain about, then the fact that in Mr. Parr's case there's been an extended normal retirement date on terms doesn't matter one bit. And one can also see that from the fact that when we look, as we may have to do at Selden shortly, to look at the justification exercise that has to be carried out in respect of an age discriminatory term, one isn't looking at the subjective characteristics of the individual, but instead the general considerations which would justify a retirement age in a particular business. And indeed, Selden itself was a case where there was a discretion built into the clause. But nonetheless, it's the general justifications which apply. Can I just seek to make the point good, if I might do so, about the irrelevance of when the policy or the regime is actually applied to the individual, and the significance of the simple existence of the term, the regime, or the policy.
The regime or policy, you're saying in effect that any contract of partnership or employment or anything else with a retirement date is by definition direct discrimination, and the retirement date always has to be justified in any discrimination claim, and the discrimination goes back to when the employee or partner started work.
I'm saying exactly that. Unless and until the contract is terminated or the term itself is abrogated. I'm saying exactly that.
So, perhaps I'm not up to date with the case law, but it must be that every time anybody is made to retire, it could be from employment, as it happens, this is a partnership, at, say, the age of 65, on their way out, so to speak, they can say, I don't want to retire, I want to go on for the rest of my life. But this is a discriminatory rule which has existed since I started work here 40 years ago. Its conduct extending over that 40-year period, and it's continuing.
Just as anybody who is party to a contract with a discriminatory term could say exactly the same thing. And the law has always permitted that. And I've shown you what the legislation prior to the Equality Act said in terms about that. And nowhere in the language of the RRA or the SDA provisions was there any additional requirement that there had to be some sort of application of the term or the rule. And why would there be? Because where one has a contractual term, application is built in. It's incorporated into the contract between the parties. Can I just press that point a little further, if I may, just by showing you, for example, what this court said in Cast.
All right, I thought you were going to take us to Seddon, but
well, I'll do that next, if I may.
All right.
Start with
whichever
Cast. I'm doing it this way because I made the point to my Lord Justice Lewis that application irrelevant.
Yeah. This is why I'm saying it's not application, you see. This is why I'm saying the question is, what is the contractual provision that determines that Mr. Parr retires at 62? And the answer is clause 29.4. It's no longer clause 29.2. Indeed, that never applied to him in the event, because it was agreed that a different normal retirement date would apply to him.
Well, my lord, I do take issue with that.
With that, yes.
But clause 29.2 did apply to him. It applied to him for two reasons. First of all, it applied to him because he was a party to a contract which incorporated it. Yeah. And I say I need to go no further than that at all.
It's my fault. I've used the word applied loosely. Clearly, it was a part of his contract of employment right up until, I'm calling it the variation, that he would have retired at 60. In fact, it never got to that, and the clause was never put into operation at age 60 because a different normal retirement date was agreed pursuant to the terms of 29.4.
Well, I wouldn't, my lord, agree with that either.
No, I know you don't.
It's a well. I'm sorry. I didn't mean to be rude.
No, it's fine. That's
When I said that, but 29.2 does operate. It must operate because unless 29.2 bites, the discretion under 29.4 never arises.
No, it depends how you read the word subject to. Clause, you have, your case depends on, as you said at the outset, funneling. You go into 29.2 and then you come out into 29.4.
Yes.
But these are clauses that determine what the normal retirement age is. And unless 29.4 applies, it'll be 60.
Well, they don't.
If 29.4 applies, it'll be a different age.
But 29.4 doesn't just do that. 29.4 has a range of possible outcomes, all of them detrimental to the member, because you don't come out again with the same rights as you had before.
It all depends on what you agree. You may agree a 62-year date on exactly the same terms. And they did, I gather, for some people.
But that is detrimental to the member, because what the member had prior to going into 29.2 was unlimited membership. They could carry on to 70, 75 if they wanted to, but now they can only carry on till 62. So 29.2 always operates, and if there wasn't 29.2, there wouldn't be the discretion under 29.4.
29.2 provides the very practical reason why, if you don't agree a new date, you're in trouble because you'll be out. And if you went to 60 and you didn't have an agreement, that would be the date at which you would retire. But there is provision under 29.4. We're just repeating ourselves.
Yes, well, there you are.
Perhaps we'd better look at the cases.
Yes.
Yeah.
So if we turn to cast, please.
And can you just give us the
Page
the-
63 of the authorities bundle.
Yes.
So a decision of.
Is it mentioned in your skeleton?
I'm sure it is.
Say.
Yes, it's paragraph 23, bundle
Yes.
page 25.
Got it. Right.
And I am sure I will return. Yes, if you have a look at 33 of my skeleton, which is page 28, what I've set out there is some language that the EAT quoted from cast.
Would you like us to look at cast?
I think it's probably best to look at it actually,
Right.
my lord, and we'll need to go to 508, which is bundle page 71.
Can I just check the facts first? Give me a moment.
Yes. And the particular passage I'd like to look at, please, is bundle page 71 in the judgment of Lord Justice Old. And if my lords and my lady look about just over halfway down the page, the paragraph begins as to a one-off discriminatory act. Now that passage, 7 or 8 lines long, is relied upon by the Employment Appeal Tribunal. So could we start, please, by looking at that?
508.
508,
Yes.
and
What?
as a one-off. And then if the court might please read on to over the page on 509 at letter B, which is a subsequent text that the EAT did not recite. Now, if I could start, please, with the passage that the EAT did rely upon. Well, it seems to me that what the EAT thought that meant was that there might be a discriminatory act which was said by a claimant to flow from a discriminatory policy or rule or regime, but nonetheless time might start to run from the act and not from when the regime was abrogated. And that's not what the passage says at all. You only have to read on to the remainder of what Lord Justice Old says to see that that's not what he's saying. What he's saying is that if you're a claimant and you are only complaining about a particular act, but not in fact about a policy or a regime or a rule, that the fact that the act might have been the product of a regime or a rule doesn't matter at all. But then you have to contrast that with what he says towards the bottom of the page. It is the existence, opposite H, it is the existence of a policy or regime, not a specific act of an employer triggering its application to the complainant that matters. And then the next sentence deals with my lady's point about this being a deeming provision. The language shows you that that's why that is what the legislation means. And if we are over the page at 509, at letter E, there is some commentary on Amy's, which we'll look at shortly. And that makes the point that where you have a policy which is still in place at the time of termination, time runs from that point. That deals with my Lord's point earlier. Well, what do we take from that? The reason why I take issue with what my Lord Justice Lewis says is exactly because of what Lord Justice Old says at the foot of page 71. That the fact that the normal retirement age may have been, let's call it amended for present purposes, but the fact that it may have been amended in Mr. Parr's case matters not one bit. It wouldn't matter if that was never done, if it was done, the date on which it was done, because the complaint is about the term.
But in Carston Croydon College, it seems to me an illustration that the proposition that reported case is always easier than the one you're trying. the reported case. Employee just back from maternity leave. Can I work part-time? No. Can I work part-time? No. Can I work part-time? No. All right, I resign. Of course, that's conduct extending over a period. How can it not be?
But that's not the conduct. The conduct extending over a period is the underlying regime,
Yes.
policy,
Yes,
whatever it
of
may
course.
be.
Well,
The underlying regime was they wouldn't allow part-time working.
Yes, that's an important point, because what that shows you is it doesn't matter how many times the female employee says, I want to work part-time. It doesn't matter how many times the employer refuses to allow that. What matters is the underlying existence of the policy. She might never have made the request at all, and she could still complain about it. She might, just to take what my lord said to me earlier, she might have been employed for 40 years and not said a peep about it. But nonetheless, if the policy continues throughout that period, within 3 months of the end of her employment, she's entitled to complain about it. And there's nothing controversial in what Lord Justice Old says here. It is, in my respectful submission, wholly consistent with all of the authorities. It is the law. And it's an absolute answer as to why getting into the weeds of what happens under clause 29.4 is irrelevant to the determination of this appeal, because it's clause 29.2 in its unvarnished state which determines when time runs in this case.
Well, I'm not sure how this policy analysis applies to the facts of caste, because at 503E2F, it says that the college had a written policy which was receptive to proposals of job sharing to all levels.
Yes, I think the point being made is what the claimant in caste was entitled to do was to say at trial that the number of times that she was refused were evidence from which one might be able to discern that there was an underlying policy, and that would have to be determined at trial. But nonetheless, there was enough for that issue to go to trial. And if it was determined that there was a policy, well, then the time consequences would flow from that.
Right. Doesn't sound like a very promising argument, but anyway.
All right, so we need anything else from caste?
We need nothing else for the moment from caste. I've gone rather out of order, for which I apologise, but I've been trying to deal with the court's questions as best I can.
Yes.
I think logically where I've got to next is to look at the Amy's line of authority.
Yes.
And in the light of that, I'll start with Amy's itself. And that's in the authorities bundle at page 8. So Amy's is a school teacher case, female school teacher. She wants to be head of department. A male teacher is given the role instead. And it's a factual feature of the Amy's case that Mrs. Amy's does not say that there is some sort of rule in place to the effect that a woman cannot be head of department. And so perhaps unsurprisingly, the EAT find that the non-appointment, the head of department role is one-off and time starts to run from the non-appointment. But what matters is what the EAT say about what the position would have been if in fact there had been such a rule. And to see that, we go to page 11 of the authorities bundle. Mr. Justice Bristow, and it's the paragraph opposite letters E and F.
If there was was a policy, head of department is only open to men, then that would be a continuing. Of course.
Yes, but I would say entirely indistinguishable from the present case. Indeed, the only problem Mrs. Amy's might have had at trial would be in actually identifying that policy and obtaining evidence of it. A problem Mr. Parr doesn't have, because here the rule speaks for itself because it's a term of a contract. But the important point to make about Amy's is that what Mr. Justice Bristow says doesn't depend upon any application of the policy. For example, their head of department, male head of department, might have been appointed on a 10-year fixed-term contract. Mrs. Amy's might have been 2 years away from retirement. There might have been no further opportunity of any kind for her to ever apply for that role again. But the reason why her time period for bringing a complaint continues up to either the termination of her employment or the abrogation of the rule is that it's the rule that matters, not anything about her particular circumstances. And you see that's precisely what Mr. Justice Bristow says. For so long as the rule was in operation, there would be a continuing discrimination. And I'm sorry.
This is why, if you try and translate the fact, if you stand back now, what was wrong with the Amy's case? If they're not going to have women as heads of department, then that's wrong, and therefore it should be stopped. But if in fact it was a one-off case and it happened ages ago and she didn't complain about it, well, that's her responsibility. So then you go to this case, you say, well, what is the proper analogy here? And I do understand why you say it's 29-2, but the proper analogy, or is the proper analogy here, you're dealing with a situation where you're going to make people retire. When? Answer, it all depends. You have to look at the whole contract. It'll be 60, or it'll be a different date. It could be 62 and equity partnership. It could be 62 and non-equity partnership. It all depends, because you can't just read the rule 629.2 in the abstract. That will provide the answer if nothing is agreed. It'll provide the very strong motivating force for the employee who wants to stay on to say, excuse me, I really do want to stay, and I'm just as good now as I was yesterday. But at the end of the day, the situation here is slightly different from Amy's, because it's not either a specific act or a provision, no women, full stop, throughout the whole of the period. This is a situation where you're trying to work out what is a person's normal date of retirement. And I do still wonder whether you can really read 29.2 in the abstract, ignore the word subject to, and ignore the text of 29.4. But we've had that debate, and you say I must do.
Well, my lord, I'm not seeking to read 29.2 in the abstract. Well, again, maybe I haven't articulated it very well. What I say about 29.2 and 29.4, even if you take them together, is what they're doing is 29.2 is discriminatory, subject to justification. What 29.4 does is give the LLP the potential to partially ameliorate the discrimination. It could be very bad or not so bad, but there is always going to be discrimination whichever way, because even if the partner is very favourably treated within the discretion and gets a time-limited extension, nonetheless it is a time-limited extension.
Again,
and that's well, I'm sorry, my lord, but that certainly for my case, that's the critical point when one is looking at detriment for discrimination.
I do understand you're approaching this from the kaleidoscope of how do I put these things into the Act, and that's how I do it. And there'd be differential treatment. People are going at 60. They can mitigate that. If they mitigate it, they may not be lost. But I'm just saying, forget the law for the moment. Two people sit down on either side of the table and reach an agreement. What are they doing? They're deciding when somebody must leave. And they're saying it'll be 60 or it'll be something else, depending on what we agree. And the question then is to decide how that fits into the Act, not applying the Act first and then analysing the concepts in the light of that. Is the normal retirement date fixed as a result of 29.2 and 29.4, in which case it was 62, but he wasn't an equity partnership, and that was agreed in 2 years earlier, or was it 60? That's all I'm saying. And I'm trying to work out what the contract was doing before I seek to apply the prism of the Act to it.
Yes.
You follow me?
I do, my lord. I do follow that. The reason perhaps I look at it through the other end of the telescope is because I say the position on both the authorities and the statute is a much more straightforward one, which is that as soon as one identifies a discriminatory term, that is enough. So until that term is abrogated or the contract terminates, the conduct continues. So because it is as simple as that, one doesn't need, in my respectful submission, to get into the weeds about the way in which all of this operates.
Yes, I don't get into the weeds. I just tip my toe in and I see the very first words of 29.2 are subject to. Oh gosh, there's more to life than that, so I have to read 29.4. That's all I'm saying. I've said it repeatedly, so I won't say it again.
Yes, well, I'll show you. Yes, well, I'm sorry if I'm not dealing with it very well. But
we know the area of dispute at the moment, yes. I'm only testing your argument. I haven't come to any view yet. We're just testing it. Anyway, I've said it 2 or 3 times, so don't worry.
When Mr. Parr was 60, he and the partnership agreed that he would continue to be, I'm trying not to use phraseology which begs the question, but an agreement was reached under clause 29.4, under which he would be a non-equity member with a normal retirement date of 62. I think on your argument, that agreement itself, or the term in that agreement which says you must retire at 62, is again direct discrimination. So that's a new act of discrimination, and that discriminatory term is the term of his contract for another 2 years.
I don't put it quite like that. What's that?
Well, why not? If you're right that any retirement date clause in any contract of employment or partnership is by its nature direct discrimination, why isn't the new one direct discrimination just like the old one?
Well, I can see the argument. It just seems to me there might be another way of looking at the situation, and it involves an examination of Selden.
All right. Should we go to Selden?
Yes.
Then?
Let me park the Amy's line of authority and go to Selden, because. So page 134. And you can see the ratio of Selden from page 134 itself, opposite or just above letter G. A distinction had to be drawn between social policy objectives of a public interest nature, which could justify direct age discrimination, and purely individual reasons particular to the employer's situation, which in general could not. So what that tells you is the debate in Selden. Mr. Selden said to the Supreme Court, well, actually, in the justification exercise, what an employer has to do is deal not only with general reasons for a retirement age, but also the specific application of that retirement age to any particular employee. The Supreme Court said in general that's not the case. I'll show you the term itself, which is at 138, opposite letter H. So there is also a discretion in the term, albeit a somewhat different discretion to the one in the instant case, because the discretion in Selden would allow simply postponement of the date rather than amendment to terms. If we turn on to...
It's more rigid. I mean, if that's the only clause that matters, you either stay on the same terms or you're out.
Yes, I agree.
Right.
And then we turn on to the issue of justification. You can see at 63, page 153, that what Baroness Hale is dealing with is whether the measure has to be justified, not only in general, but also in its application to the particular individual. And at the top of the next page, top of 154, the argument on behalf of Mr. Selden, therefore, is that the partnership A had to show that its particular less favourable treatment of him B was justified. So that's the debate. Are they purely general reasons or also specific reasons? 64, the answer given by the EAT and the Court of Appeal was typically legitimate aims can only be achieved by the application of general rules or policies. And at the end of 64, thus the appeal tribunal would not rule out the possibility that there may be cases where the particular application of the rule has to be justified, but they suspected that these would be extremely rare. And at 65, Baroness Hale says, you need to look at the first two lines, I would accept that where it is justified to have a general rule, then the existence of that rule will usually justify the treatment which results from it. Now, what does that mean on the facts of a case like this? Well, as a starting point, it means that 29.2 has to be justified by reference to general considerations, dead men's shoes, allowing younger partners to move up, etc., etc. But the complicating factor, of course, is the exercise of some discretion under 29.4, and the question then is whether it's one of the rather exceptional cases that the Supreme Court seems to suggest may still be a possibility, where there also has to be some degree of justification by reference to specific circumstances rather than just general circumstances. So that certainly is why we complain in the ET1 about the exercise of the discretion. It's an issue which goes to the nature of the justification. I accept that.
You're jumping ahead to the case on the merits, and we're concerned with the dry question of whether this was conduct extending over a period. What does Selden tell us about that?
It doesn't deal with that issue. It wasn't a live issue in Selden.
Yeah.
But, my lord, the justification point is important because what it shows you in respect of a clause like 29.2 is that ordinarily that's justified by reference to general rather than specific circumstances. And what one takes from that is that the nature and timing of the application to a particular individual doesn't matter.
It raises the question that my lord raised earlier. What would have to be justified here? Dismissing Mr. Parr at 62, because that's what's happened to him.
No.
Or agreeing a date which involved him having less favourable terms.
What has to be justified here is clause 29.2, and that's having a normal retirement age of 60.
Yes.
But he didn't have that as his retirement date.
Well, I think that's where my lord and I disagree. It is true that there was not compulsory retirement, but clause 29.2 was applied to him and a discretion was exercised so that his treatment was something short of absolute retirement.
The loss is different and greater because he agreed to 62 on different terms. When you come to 62, if he seeks to argue that 62 is wrong, you shouldn't retire people at 62, his loss would be by reference to the lower salary and without the equity partnership. If, however, you go back to an earlier stage of discrimination when he had the equity partnership, then you've got to identify what it was that gave rise to that discrimination and how that can be built into the calculation. That's the issue. It's the loss that you use to calculate if he's been unfairly dismissed at 62.
Well, I've put my case very squarely on 29.2.
You've got to, I'm only saying the same thing in a different way now.
Yes. Sure. Mr. Carey, let's let you continue your progress through the case law.
Yes.
So we've had
Amy's.
We've had Cast, Amy's, and Selden. Where do we go next?
Holder, which is page 15. And I can be very quick about this. This is falling on the other side of the Amy's line, and it's falling that way because there is a discernible policy in this case. All that one needs to look at is the foot of page 17. And there's a long paragraph beginning, the complaint. And I think all we need to do is look at the last 5 lines of that paragraph. By constituting a scheme under the rules of which a female could not obtain the benefit of the mortgage subsidy, in our judgment, the employers were discriminating against the applicant in the way they afforded her access to the scheme. It follows in our judgment that so long as the applicant remained in the employment of these employers, there was a continuing discrimination against her.
While you're in that, if you could look at the passage just 2 lines above that, which says that the evidence established that it was a requirement of the mortgage scheme that the applicant should be a male and not a female.
Yes, I mean, self-evidently so, or it wouldn't have been discriminatory.
Sorry, where was the passage that?
That's about 5-6 lines down. In fact, it's probably respectfully best to just read the paragraph.
Yes. Well, no mortgage subsidy for female employees is like no pension for black employees. It's obvious direct discrimination which continues for the duration of the employment. Right. Okay.
Yes, all I would say about that is my Lord says it's obvious that it continues. It continues because of the existence of the policy. It doesn't matter when Mrs. Calder makes the request or when there is a refusal. The statute ignores all of that and simply looks at the existence of the rule. And that's the point that it's important to have in mind. We go on to Kapoor, page 19, which ties the threads together in respect to these 2 cases. Now, important to note in Kapoor what the facts are. So these are joiners to the bank, predecessor of Barclays, and what the bank refuses to do is to recognise their previous service. So it's right to say that there are continuing consequences of that. It's going to affect their pension in the future, but there is what is on the face of it, absent there being some underlying policy, a one-off decision not to credit them with their previous service in East Africa. And you can see that simply from the heading. 356, page 20 of the bundle, letters A and B. We've already been to page 31, where Lord Griffiths dealt with the issue of the significance of Lim A of the then time limit test, in other words, term of a contract, and that couldn't apply. So I don't want to go over that territory again. It follows that what the House of Lords is constrained to do is to see if, notwithstanding the fact that the complaint here is about a term of a contract, it nonetheless fits within Lim B, i.e. act extending over a period. And that's the part to which we now turn. And it begins at 32, page 32 of the authorities bundle. And I just take you there because it shows the reference opposite letter B to Amy's and opposite letter G to Calder. Page 369D, in the present case, the Court of Appeal were, in my view, right to approve these two decisions and to classify the pension provisions as a continuing act lasting through the period of employment and so governed by subsection 7B.
Again, to save going back to this, if I could invite you to read down to letter F, please.
I was about to get there, but I'm happy for you to read it.
On 367.
369.
9.
369.
D to F, is it?
Doesn't one, Mr. Cohn, have to bear in mind into which box in the then statute the discrimination which was alleged fitted? If you look at the top of page 30 in the authorities bundle, 366A to B of the report, Lord Griffiths refers to the relevant provisions.
Yes.
And they're either terms of employment being less favourable, subsection 2A, or there's discrimination in the way they are afforded access to the benefits of the pension fund.
Yes, and that's almost...
TB. So that's the type of discrimination which is alleged. And doesn't that cast some light on whether there's a one-off act or a continuing act?
Your Ladyship, that language is almost identical to the language that you now find in section 45. which I handed up this
Yeah.
morning, and I agree with you. It is indeed illustrative, and
Well, it's not illustrative, it's the framework within which the claim had to be brought.
yes, but what it does is help to understand how the time limit provisions fit with the various types of discrimination, and why one can see how a term of a contract case speaks for itself in respect of time limits, because at section 45(2)(a), the very first form of discrimination is as to the terms on which B is a member. And for so long as those terms continue to be incorporated into the contract, there is conduct extending over a period, we would say. So that's Kapoor. The next authority in that line I've taken you to already, which is Sugran. I don't need to go to that again, just to point out what Lord Donaldson said there about the insignificance of application and the importance of the rule, term, regime, whatever it may be itself. And finally, in this section, it's the authority on which my learned friend relies at page 177 of the authorities bundle, Ike Giacu.
And this is Mr. Justice Sewell.
Yes, and my learned friend says in his skeleton this is on all fours with the present case. So that's why I need to shortly
Yes.
list it.
Yeah.
In fact, it's on, well, if I can put it this way, not one of its limbs has anything to do with the present case. If we look at the summary at page 179, second paragraph, in its remedy judgment, the ET held one time issue that the introduction of the new contract in March 2016 was a one-off effect with continuing consequences, not an act which extended over a period. So what the case is about, one of the detriments which is alleged, these are whistleblowing detriments, but broadly similar to discrimination. One of them is being forced to sign a new contract. And if you turn on to 183, numbered paragraph 8, under schedule item D7, these are a schedule of complaints. The claimant stated the claimant was forced/tricked into a purported contract when he was threatened dismissal as he refused to sign two other contracts that clearly stated he has no entitlements and work in protest. So his complaint was not that the contract itself.
Sorry, hold on, I just need to understand the facts. Can you just give me a moment?
Yes. Can I help my lord in this way? The things are done in the reverse order. So the Employment Tribunal decide that the introduction of a new contract is an act of whistleblowing detriment, but haven't yet looked at the question of whether the complaint is in time in respect of that. And then subsequently they examine the time point, because the claim is brought long after the new contract is introduced. And what you see from paragraph 8 is that the complaint is not that the new contract, or indeed any other contract, includes a discriminatory term. the introduction of the new contract is said to be a detrimental act. And unsurprisingly, in the light of that, paragraph 28, Mr. Justice Sewell Mr. Justice Sewell 28 emphasises that what is complained about, line 3 of that paragraph, C, was forced/tricked into a purported contract. The thing that's being complained about is the forcing and the tricking, not any term within the contract. Paragraph 31, you can ignore the first sentence and what follows because there's an attempt to bring into play other acts that were found not to be unlawful, to try and stitch things together in a Hendricks type way, and that fails. Halfway down at letter G, accordingly, the focus must be on the act of the requirement to enter into a new contract. Was that a once and for all act or a continuing act? 32, this type of distinction has provoked considerable litigation, Kapoor, Sugran, Coro, etc. 33, the act in the present case does not constitute a policy or rule. And one can read the rest of that paragraph. The judge is absolutely right. There plainly is no policy or rule. There's a one-off act. It's nothing to do with the situation that this court is dealing with, which is about discriminatory terms in contracts, as opposed to the imposition of a contract as a discriminatory act. So that doesn't take matters any further. My lords, my lady, I'd said I wouldn't go to Sue Gran. Can I just do so very briefly at page 41? And again, I'll tell you all you need to know about the facts of Sue Gran, which is that the complaint is about a refusal to upgrade a black nurse. The argument is whether there is an act extending over a period. And I shall just show you page 45 at the bottom, opposite letter H. In my judgment, the analogy between Amy's case and the present case is close. Mrs. Amy's was not appointed head of department and continued as deputy head, presumably at a lower salary. The applicant was not upgraded to grade F and continued at grade E at a lesser salary. There was no rule that a woman could not be promoted to head of department. It is not suggested here that Haringey had a rule that a black nurse could not be promoted to grade F. And if we carry on to page 47, between letters C and D, Lord Justice Balcombe says there is no suggestion here that the applicant, Mrs. Sue Gran's contract included a discriminatory term. So once again, Sue Gran falls on the Amy side of the line, and it falls there because there is not even a case being made to the effect that there is a discriminatory term or a rule. So that's what I want to say about the Amy's cases. The final point I want to deal with was, I think, the fifth in my list, was what I said was the EAT's second wrong turn.
Yeah.
Which is a determination that there has to be a rule or policy, whatever one wants to call it, in action. And I have rather touched on that already in some of the debate that I've had with the court. But it's useful just to look at what the EAT says about that particular point. And you can best see it from Yes, I think 51 is important. So the EAT starts rightly by saying, page 93, paragraph 51, Mr. Cohen placed considerable reliance on the obiter passage at page 311E of the report of Amy's, approved in Kapoor, regarding there being actionable discrimination for as long as the discriminatory rule was in operation. And that's absolutely a fair summary of my submissions. As Mr. Stillitz pointed out, the significance of that passage in Amy's was explained by the Court of Appeal in Tyagi, per Brooke Llp as being in relation to claims under what were then Section 6.2 of the SDA and 4.2 of the RRA 1976, in respect of employees being discriminated against by an employer in relation to access to opportunities for promotion, transfer or training. And then there's a long extract from Tyagi. That echoes a point that my lady made to me a few moments ago, so I want to come back to it. And then the conclusion reached by the EAT appears on page 95. And all you need to do, I think, is look opposite D. Brooke Llp went on to refer at 26 to the need for the allegedly discriminatory practice to be in action in relation to the particular claimant, which it was not on the facts of Tyagi. In the present case, the claimant's complaint is not, unlike the scenario in Amy's, explained in Tyagi, that he was continually denied access to opportunities for promotion to equity partner after 30 April 2018. And then the conclusion is it's a one-off event. So the EAT relies very heavily on Tyagi, apparently for the proposition that one has to show that the rule is in action, those words being the words used by Lord Justice Brooke in Tyagi. So it follows that we have to look quite carefully at Tyagi, see whether that conclusion was rightly drawn or not. My lords have Tyagi at page 81 of the authorities book. And one has to immediately identify something critically important about the facts of Tyagi, which is that it's not an employment case, it's an applicant case. So this is a person who is seeking employment, but is not an employee. In fact, he has previously been an employee of the BBC, but the complaint he's making to the Employment Tribunal is one of non-appointment to a position that he's applied for, and he's bringing it long after the expiry of the 3-month period from the non-appointment. And my lords can probably best see that from paragraph 4. On 24 March 98, the applicant wrote to the respondent complaining of his treatment at the interview in April 1997, and then paragraph 5, 16 July 1998, he presents an originating application to the Employment Tribunal alleging that he had suffered race discrimination through the respondent's selection process for the BBC World Service post. The application was a year over the 3-month time limit provided by the statute. Now, immediately one can see on the authorities that I've already shown to this court, Mr. Tyagi has a problem, because even if he can identify that the BBC has a rule, a regime, whatever one wants to call it, how can it be in operation in respect of him? Because other than the time at which he's actually applying for the job, he's not an employee. There's no contract in place between him and the BBC.
Is that right?
There is then some consideration of some of the authorities that I have referred you to this morning. And at 50...
You say he wasn't an employee when he was turned down? Paragraph 3 suggests he was.
Well, if my lord counts up 1, 2, 3, 4 lines from the bottom of paragraph 3, his employment with the BBC ceased in July 1997, and his dismissal was the subject of separate proceedings which were started October 97 and compromised in February 98.
It's impossible to read. There's no bigger copy of this, is there?
I'm so sorry.
No,
I think it's discrimination against those with elderly eyes, this report.
I do apologise. So
The discrimination complaint is in respect of his being turned down in 1996 twice.
if you look at paragraph 4,
Yeah.
he's complaining of treatment in April 97. Paragraph 5, he presents his complaint in July 1998. So his difficulty is that even if he can show a regime or a policy or whatever it might be in place throughout the currency of his employment has long ended.
Yes.
And as I've indicated, one can't show a policy or a regime which applies when one isn't employed.
Yeah, but what we are trying to distill from this minute script is whether, when they use the word inaction, that's what he was referring to, i.e. because the employment had terminated, therefore there can be no rule now applying.
Yes.
Or whether the word inaction was used differently and referring back to the events that occurred in April, June, July 1997. And without a magnifying glass, it's almost impossible to tell what that paragraph, which paragraph is it that tells us what the inaction was being applied to?
Well, if you have a look at, and I do apologise for exercise, if you look at paragraph 21, for example,
where did the phrase inaction first appear? Is it 16 or 18 or?
Is it 20?
25.
I don't think it appears before 25. If I could just invite my lords and my lady perhaps to start at 15, and I know it's very small. What 15 does is to deal with Mr. Justice Bristow in Amy's. And the paragraph begins by saying, it is to be noted that in this passage, Mr. Justice Bristow makes no distinction between section 6.1 and section 6.2 of the Act. What section 6.1 did was deal with applicants for employment, and what section 6.2 did was deal with existing employees. Just in the same way that in section 45 I've handed up, 1 deals with applicants for membership and 2 deals with existing members. And the point being made in the remainder of paragraph 15 and 16 is that there is a distinction to be drawn between 1 and 2, because the Amy's approach applies only to employees, i.e. those with an ongoing relationship, rather than applicants who have no ongoing relationship. So that's what is being dealt with here. And then
Surely it's not that it's an application for promotion case. Mr. Tiagi's problem is that after his applications to be a producer in the Hindu service are turned down, he resigns and doesn't bring his tribunal claim for a year after that. So at that stage, he's an ex-employee, and you can't say that the discriminatory acts, assuming that's what they were an act extending over a period ending within 3 months before he presents the tribunal claim?
Well, you might be able to if he'd remained an employee.
No, well, he hadn't.
But exactly.
It's the fact that he's an ex-employee, not that the original application was for promotion.
Yes, I absolutely accept that. But
All right.
the point being made in Tyagi is that you can't apply the Amy's Kapoor approach to somebody who isn't an employee, i.e. an applicant for employment. You can't do that because they're not employed. So as soon as the employment terminates, there can't possibly be any further conduct extending over a period.
But you say so long as the contract continues, a refusal to promote or a demotion or anything like that is conduct extending over a period.
Yes, and indeed
Well, let's posit another teaching case. A black employee at a school, starter grade teacher, applies for appointment as head of department. She's turned down, thinks nothing of it at the time. And so she stays in the starter grade for years and years and years, and each time the head of department position comes up, a white man is appointed. Can she then say, after 25 years of service, this is a continuing act of discrimination? It can now be seen that you have a policy of only appointing white men, and my damages are 25 years of lost earnings. I think you would say she can.
she can undoubtedly say that.
Nothing wrong with that.
No, she can undoubtedly say that. She, I mean, obviously there may be difficulties at trial in establishing that there is that underlying policy, but even at the preliminary stage, if her case was that there was such a policy, it would survive any attack on time limits. And if at trial she succeeded in knitting together those events to establish evidentially that there was the policy, a claim would be in time.
Okay, that's Tyagi.
Can I just before leaving Tyagi, the critical passage I think I'd alerted the court to was 21, but also one needs to read 25, and it's plain from those passages that what the judge is talking about when he uses the words in action is that there is some ongoing relationship, and the policy can't be in action where somebody isn't employed. So Tyagi is a decision which doesn't take us any further at all.
In the example I just gave of the teacher, if she, after the first couple of times, resigned, left, went to work for another employer altogether, but then, as it were, from a distance was able to observe that the original employer just kept on appointing white men, she could not say that this was discrimination, a discriminatory act extending over a period ending within 3 months before the claim. She might have a go under just and equitable, but that's a different point.
Yes, exactly that.
Yeah.
She'd be out of time. And indeed, a claim about a policy of that kind that somebody who's not an employee would wish to make has to be made by the appropriate authorities in the ordinary case, as Tyagi makes clear. But yes, just and equitable would be...
Speaking of that phrase, something which occurred to me reading the papers, why was the ET decision in this case limited to conduct extending over a period and did not go on to say whether the judge would have found it just and equitable?
not, I think, by the invitation of either of us. It was fairly fully argued, I think.
I mean, in cases when I used to be in practice, sometimes where as here, there's not long and complicated facts which need inquiry. Wouldn't it have been better for the ET to be asked, is this a conduct extending over a period? If not, would it be just and equitable? And if you find in our favour on point 1, would you nevertheless go on to consider point 2, so that there aren't potentially 2 lots of appeal proceedings?
So, my lord, we plainly at the hearing we advanced both issues. The employment judge decided only one of them, and it was not in our gift to have both decided. The judgment said what it said when it came out.
Oh, you did argue.
Oh yes,
both points.
Oh yes, but prior to, obviously permission to appeal here was given by the EAT. We sought to have the Employment Tribunal deal with the just and equitable issue first before this hearing came on.
Yes.
Because we were conscious that we are now in a cost-shifting regime.
Yes.
Time in this course is very valuable. The Employment Tribunal refused to do that because the respondent resisted it. So we are here. I don't want anything I say to take away from the force of my submissions, but we are here unwillingly in the sense that we would rather have dealt with just and equitable first.
Right.
Lords, so that's why Tyagi is not a decision which takes matters any further, and the fact that the Employment Appeal Tribunal, I should say, have to rely on Tyagi to draw from it the proposition that there must be a rule, a policy, a term, whatever it may be, in action, indicates that there is no authority that says anything else in the context of an employee or a member. In other words, there is no authority for the proposition that the mere existence of the term, the rule, or the regime is not of itself sufficient to stop the time clock from running. Now, the final thing I want to do is to touch very briefly on the authorities relied upon by my learned friend, just to indicate to you why they also are unhelpful, because they're not employment cases. They're either non-employee cases, qualifying bodies, for example, or they're applicants for employment. None of them are dealing with an ongoing relationship. So you will have seen in his skeleton mention of Rovenska and Chowdhury.
Yeah.
They're both qualifying body cases. I won't go to Rovenska, I'll just go to the later of them in time, which is Chowdhury, and that's at 101 of your authorities bundle. They are both of them doctors who are seeking to qualify, and the qualifying body is, for one reason or another, saying no, and the doctor wishes to make an allegation of discrimination. I'll show you, please, at 119 what Lord Justice Mummery says in Chowdhury. Could I invite the court, please, to read down from letter B on 119 down to letter E?
Sorry, can you just give me a moment to have a little glance at the head notes?
Yes, I'm sorry.
What the issue was.
plainly it's the second half of 67 on which I would place particular emphasis, though I say it's an obvious point.
But why did he lose then?
I'm sorry?
Why did he lose? Because really it isn't any different. It's because it's a scheme. The condition is still there. If Mr. Chowdhury had come back again, he'd been told, go away. We've already told you. You don't qualify under the rules.
Yes.
Should have won, shouldn't he?
But what he can't do is point to continuing conduct.
But you shouldn't have to on your analysis, because once you've got a rule, in this case the scheme, saying you must have certain things to be registered at a certain level, they're continuing to apply that to him. It's very odd.
But they don't, because he has no ongoing relationship with the qualifying body. There is no contract in place between them. There is no framework within which the rule, policy, term, whatever it may be, has any application. That's the significance of these cases. And it's why Lord Justice Mummery says they're distinguishable from the employment cases. I have never said to my lords...
No, I understand. I see now what the difference is. I now don't know enough about doctors to know how it works. So.
Then these are not cases by doctors against the hospitals
no, they're against
that employ
the qualifying
them.
board.
Qualifying
that, yes.
The critical difference. I have always said to this court that the time period for Mr. Parr to bring his claim was 3 months after either the abrogation of the term or the termination of his membership. It's not just the continued existence of the term which determines the time period. He has to remain a member and so subject to that term by virtue of the members' agreement. And the difficulty in these medical cases is that the policy or the regime might remain, but the doctor is not subject to it because there is no agreement of any kind between the doctor and the qualifying body.
There's no relationship within which the rule operates. There's an attempt to create a relationship.
Precisely that.
And in that situation, you do it from the time you refused entry at the door.
Exactly that.
What do you say?
Exactly that. So that's why, and I won't trouble you with Ravenska because it's exactly the same.
Yep.
So Ravenska and Chowdhury take us no further at all. They are, as Lord Justice Mummery said, obviously distinguishable. They're dealing with a different issue altogether. My learned friend also relies upon a decision named Okoro, which you have at 158 of the authorities bundle. Now, Okoro is a case where temporary workers were banned from a building site. And they say that's an act of race discrimination. It will follow immediately from the way I describe it as a ban from a building site that there was no ongoing relationship between the workers and the construction company who they wished to work for. They were in the position of applicants for employment. And if my lords and my lady read the head note, you will see that immediately.
Well, the head note suggests there was a relationship, but
I don't think My lord, that's right. These are people who are seeking work. I think perhaps on day one they do a few hours work, but they're seeking work and they're banned from the site. They come back again, try and get work, the ban continues, and they're complaining about the ban. And if one looks between letters E and F, the latest date on which time could begin to run was 18 April 2008, which was the date of final imposition of the ban, if I can put it that way, the last day that they come to the site.
The facts are set out in paragraph 8, where one sees that they were repeatedly assigned to the site and then told there'd been a mix-up and they should go away. Paragraph 8 deals with that.
So they're in the position of applicants for employment.
Yes.
And if one goes to paragraph 33 in the judgment of Lord Justice Pill, I need to show you only two extracts. Just above letter F, there is no ongoing relationship within which it can be said that the protection bites in relation to the claimants it was submitted. The subject matter of the complaint is no longer in action. So that's the point being made on behalf of Taylor Woodrow. Paragraph 35, I substantially accept the submissions of Mr. Cooper as already summarised, and I can state my conclusions briefly. And then 37 is the passage I would invite the court to read.
Yes. Well, this is a very straightforward case, but it's an applicant for employment who's
Yes.
never been on the site.
But my learned friend relies upon this authority to say that one has to show a policy, a rule, a term, whatever it may be, in action. And it's important to see what that actually means. In fact, I've only got one more authority to deal with, which is King. And what I then will have done is to deal with every one of the authorities on which my learned friend relies for the proposition that there must be something in action, just to keep using those words. And in fact, one can see that every single one of them is dealing with a factual scenario where there is no ongoing relationship.
So inaction means really relationship giving rise to problems. Yeah?
Where there is a contract that incorporates a discriminatory term,
By
inaction
definition,
is built in.
By definition.
It is. There is no separate qualification. And where it leads me, I'll make the submission now before I've dealt with King, where it leads me is that once one discounts every one of the authorities on which my learned friend relies for the proposition that there must be something in action, some additional requirement over and above the simple existence of the contract, he has no authority for that proposition at all. And in fact, he would say that I'm trying to persuade this court of some novel proposition. He's trying to persuade this court of some novel proposition. What I say is wholly conventional and based on 40, 50 years of discrimination law.
All you say is that where it's a term, and that term is what you're challenging, that's the end of the matter. Full stop. You don't therefore need to show a link between that discriminatory term and the specific subject matter of the claim that you're bringing at the moment.
Exactly that. One has to show that within 3 months of the ET1 being filed, there's been no abrogation of the term and no termination of the contract, and no more. So I'd said I would deal with King, which is the final one of those authorities, and my lords have that, and my lady, at 169 of the authorities bundle. Now, King is what I would describe as a stitching case. In other words, it's like a Hendricks type decision where what the employee is trying to do is to ask the Employment Tribunal to find that there is an underlying regime or policy by establishing a large number of individual discriminatory acts. So that's why I say stitching. There's an attempt to stitch all of these things together. And if my lords and my lady see the second paragraph of the head note, in December 2017, she brought proceedings in the Employment Tribunal alleging unfair constructive dismissal, victimisation under the Equality Act. And you can now skip quite a few lines, and just above the bottom hole punch on the page, about 5 lines above it, the tribunal went on to find that A's report gave rise to clear detriments, but rejected the other detriments relied upon. Accordingly, the only claim of victimisation that succeeded was that in relation to the inadequacy of A's report, which was 7 months before the claim was filed. And the appeal by the trust is against a finding that there was conduct extending over a period. So this is a stitching case where all stitches have fallen out. There's only one act of detriment which is ultimately established. It's 7 months before the claim is brought, but nonetheless the tribunal find there's conduct extending over a period. Now you can see, without even needing to dip into the judgment, why that's obviously wrong and has got nothing to do with the present case at all, because we're not here dealing with, the instant case is not a Hendricks type case, it's not a stitching case. My learned friend relies on paragraph 36 in the judgment of Mr. Justice Chowdhury. If I could invite the court please to read that. And my lords, my lady, I absolutely agree with every word of that paragraph. It's just that it has nothing to do with the present case at all. We don't rely on a floating or overarching discriminatory state of affairs. We rely on a discriminatory term, which is a different proposition altogether. So, my lords, for those reasons, I say that there is no authority for the proposition that one has to do any more than advance a case that a term is discriminatory for time not to begin to run until the term is abrogated or the contract is terminated. And that is my case. Unless I can assist you any further.
Yeah. Thank you very
Might
much.
I just take some instructions very shortly?
Yes.
Thank you, my lords, my lady.
Yes, Mr. Stillett.
Take this mask off now, finally.
Yes.
See what I look like.
It is Mr. Stillett, after all.
Yes.
Good.
In the way in which my learned friend puts his case before this court, it's notable that we've strayed a very long way from the way the claim was presented to the Employment Tribunal. Because before the Employment Tribunal, it was absolutely clear, and I'll show it by reference to the pleadings and the evidence in a moment, that what was complained of was Mr. Parr's de-equitisation, his loss of status, his permanent loss of status as an equity partner, which meant that thereafter he simply could not benefit from any events which were beneficial to the equity partners. And if I can take your lordships and your ladyship first to the pleading, the EP1, which is at page 147 in the bundle. We see the way that the case is put. At paragraph 9 at page 149. where it was pleaded on his behalf, the account date next following his 60th birthday was in Mr. Parr's case 30th of April 2018. As a result, on the 30th of April 2018, Mr. Parr was removed as an equity partner from the LLP. This was less favourable treatment because of Mr. Parr's age. And that's the first way the Act is.
I don't think one could ignore the next sentence.
It was an application of mandatory retirement age. It wasn't a mandatory retirement age. It was in fact a default retirement age. But
cross out the word mandatory.
yeah,
Point still
right,
looks good.
direct and so on. One then sees the alternative way that it's put at page 150, paragraph 11. During a meeting between Mr. Parr and the managing partner on the 8th of September 17, Mr. Parr invited an exercise of discretion in his favour to postpone the date of his retirement, pursuant to clause 29.4 of the agreement, thereby remaining an equity partner. The outcome of this invitation was communicated to him at the meeting and subsequently confirmed by email dated 10th of October 2017. The LLP permitted Mr. Parr to remain as a member until 30th of April 2020. However, that permission was on terms that from 30th of April 2018, Mr. Parr would be de-equitised. By demotion from equity partner to fixed share partner, and his remuneration would reduce. And then at paragraph 12, de-equitisation was direct discrimination in the meaning of section 31. And then if one goes on to page 153, this deals with the time point at paragraph 18. Insofar as Mr. Parr requires any extension of time to bring his claim, his reason for not doing so earlier was the absence of any knowledge by him of the matter set out in section E. That was the subsequent transactions that gave rise to profit-generating events. The consequences of de-equitisation absent these matters in financial terms was around £80,000. The consequence in the light of the matters was £2.5 million.
Yeah.
And he sought a just and equitable extension. Significantly, Mr. Parr did not seek to argue conduct extending over a period in his pleading or even in the list of issues. It was only because the employment judge said it was a jurisdictional issue that he was permitted to argue belatedly conduct extending over a period at the...
And how does that help you? Either Mr. Cohen is right that the fons ad origo, to use Latin, the origin of all of this starts with clause 29.2. He says, but for the fact that this chap would have been forced out at 60 and therefore I had no choice but to agree terms that were unfavourable, and that's a continuing rule and therefore he's within it. And he's either right on that or he's not. Well, if he's right, how does the fact that things weren't clear in the employment...
Look, I understand. I understand that point,
better.
But it is significant that he did not complain of a rule or a policy. He complained of his de-equitisation, which was a discretionary decision. It was very much that...
Well, he complains about the retirement age at 9 and 10.
Yes.
And on stronger grounds on paragraph 11, I think.
Yes. But then if one goes back, if we could briefly go back to clause 29... my learned friend, for reasons that one can understand, seeks to home in on clause 29.2 at page 29 in the supplementary bundle. Yes. The opening words of which, as has been noted, refer specifically to clause 29.4. But putting that to one side for a moment, one looks at clause 29.2. Subject to clause 29.4, each member shall in any event retire on the account date next following his 60th birthday. And I would point out that is a clause which, by its very nature, can only apply to any individual once. We only have one 60th birthday, if we're lucky enough to reach that age.
Her Majesty has two, but apart from her, yes.
Putting her to one side. One only has one's 60th birthday. Clause 29.2 is a once and for all clause, which says that unless clause 29.4 is exercised on the accounting date after your 60th birthday, you will be retired. And once you're over 60, this clause has nothing to do with you. So a 61, 62-year-old like Mr. Parr, it's no longer of relevance to him in any way, even in theory, because time only goes in one direction. Now, you may disagree with the way it's applied, but it's only going to apply to you once. Now, the other point we take, obviously, is that what this does not say, in contrast to the examples in Amy's, Parr, and so on, what this does not say is once you're over 60, you cannot be an equity partner. Very, very different to that. Clauses 29.2 to 29.4 contain a structured process and discretion for deciding, in the case of partners who are beyond their 60th birthday, whether they should continue, and if so, on what terms. The critical point in this case, and this is why I come back to the way the case was put, is that it wasn't the date of retirement per se that was Mr. Parr's complaint. It was the fact that his equity partnership was terminated. Once it was terminated, it was dead. That was it. Not to be revived, even if there were extensions to his salaried fixed share partner relationship. His equity partnership had gone, and all the matters he complains of derive from the fact that he lost his equity status once and for all.
But he says that resulted from the fact that there had to be a retirement age fixed, and if it wasn't 60, it had to be something else, and it's intimately linked with the rule. It provides the occasion.
With respect, that's precisely the fallacy in Melenfrin's argument. They're not intimately linked at all. The only significant, for the purposes of this claim, the claim here is that Mr. Parr lost out on profit share when Project Alloy and the sales BDO and all that went ahead. Why did he lose out? Because he was no longer an equity partner.
Why wasn't he an equity partner? Because he would have had to retire unless he took less favourable terms, basically.
Exactly, and the decision was, once and for all, your equity partnership is dead. It's over. Now, it's true to say, they said to him, but you can be a fixed share partner, and he took up that offer under duress, and it's accepted. But it makes absolutely no difference. It's utterly fortuitous and irrelevant that rather than taking the hard line of your relationship's over, they offered a different relationship going forwards, a varied relationship, but one without equity partnership. That's got nothing whatsoever to do with the claims in this case. And that's why saying, well, the contract was still there, takes Melenfrin no further forward, because first of all, clause 29.2 was ancient history as far as Mr. Parr was concerned. It could be applied once, it could be applied to him, end of story, no longer an equity partner. And secondly, because the fact that he was offered a different relationship was completely irrelevant to the events that subsequently he complains of. And just while we're in this, one sees that that's very much how Mr. Parr himself saw it.
But just as you're saying, the claims about loss of benefits, not the retirement date, and the fact that the loss of benefits was levered into effect because they had the threat of a retirement date is neither here nor there.
Yes,
that's it.
Yeah. It doesn't matter whether the reasons were good, bad, or indifferent, although the firm says that there were very good reasons for not extending his equity retirement date, but his equity partnership was terminated. And that is in no material way different from a dismissal. The fact that they said, actually, but you can have a different relationship with us going forward has nothing to do with this case. And one sees that from his own statement. If one goes forward in the supplemental bundle to page 119, one sees, as it were what Mr. Parr's complaint was in relation to this at para 21. He says, the only immediate effect of my de-equitisation was a reduction in my remuneration and a reduction in my status. I was unaware that my de-equitisation would have further and very substantial impact on me. And then if we go forward to page 123, at para 39, I did not take any action in respect of the decision to de-equitise me in either October 2017 or April 2018. I knew that the effect of the de-equitisation would be a financial loss, but this was not enough to persuade me to seek legal advice. I knew little about the law, etc. And then at 40, after learning that I would not share in the proceeds of the transactions as a direct result of my de-equitisation. And again, we see it at over the page, 125, top of the page. Paragraph B, I also lost benefits as a result of my de-equitisation. And this comes back to a point I'll develop after a short adjournment, which one has to focus on the relevant act. And in my submission, I'll just before I sit down, there are three submissions I wish to develop this afternoon. The first is the way my friend now seeks to put his case is not the way it was put below and does not actually focus on the material act, which was de-equitisation. Secondly, the authorities he cites in relation to a prohibition or a ban, as in some of the examples, are inapposite in this case because there was no prohibition on over 60s being equity members. It was just decided that Mr. Parr would not be. And thirdly, that there is no case which he's been able to cite where there's a rule or policy where it has not in some sense been in action vis-a-vis the claimant, in the sense of either actually affecting them on an ongoing basis, or at least potentially affecting them going forwards. Whereas in this case, it could not even in theory have operated against him once he'd passed 60. But I see the time, and therefore I will, if I may, develop those submissions this afternoon.
Two o'clock.